Lordship, if I may. Lordship, this appeal is against the judgment and order passed dated 20th February 2024 against passed in POCSO case number 10 of 2023 by the learned Special Court POCSO Bomdila. By the impugned judgment and order, the convict was sentenced to 20 years of imprisonment and direction to pay an amount of rupees 20,000, as he was convicted under Section 376 IPC and Section 6 of POCSO Act.
There are two, Your Lordship. They can through the
jurisdictional police station,
jurisdictional police station also, Your
not
Lordship.
through APP.
Routing through the office of the PP, Your Lordship.
Okay. To take steps, issue notice to the respondent number. To take steps to issue notice to respondents. Have you accepted notice?
Yes, Your Lordship.
Yeah. The learned additional PP has accepted notice on behalf of respondent number one, so no fresh steps is required to be taken. Meanwhile, certain copies to be furnished during the course of the day. Call for the scanned copies of the trial court record.
Your Lordship, if Your Lordship may call for the original, because already the case.
Oh,
has been-
sorry, not scanned copies.
Yes, yes.
Of course, original, because I am used to passing disorder scan copies in other cases, that is why. Call for the original trial court record. This is the matter of, thank you for correcting me.
After 3 weeks, Your Lordship.
Okay. This
Deeply.
will come after 3 weeks.
If not, Your Lordship, even for the LCR, Your Lordship, you have to wait 4 weeks.
Okay, issue
Otherwise,
notice returnable within 4 weeks. Respondent number 2, returnable within 4 weeks. Within 4 weeks.
within 4 weeks. Deeply.
Much obliged.
What about yesterday's? Yeah, here you are. Are you ready with the reply? Yes, yes. Yes.
Your Lordship, yesterday learned PP submitted that the confessional statement of the accused has been recorded in compliance with the provision of Section 164 CRPC. And in order to support her argument to that effect, learned PP took us to para 49 of the impugned judgment, which is at page 104 of the paper book, Your Lordship. Your Lordship, in para 49, the relevant part only I will read
Para 49 with judgment?
of the trial court judgment. Your Lordship.
Para 49 of the trial court judgment, yes.
Yes,
Page 104.
108.
104
104.
of paper book, Your Lordship.
Yes.
Your Lordship, in para 49, it is it is stated, it is submitted by learned counsel for the accused person that there is
Para
contradiction.
49.
Para 49, Your Lordship. There is contradiction in deposition of PW8. It is submitted in chief of PW8 that accused Ram Ghimire was produced from judicial custody on 3/8/2004 for recording of his confessional statement. Whereas during cross-examination, he has stated that accused was produced for the first time on 29/7/2004 for recording of his confessional statement. Now, to find out the reality of the fact, I have seen that the order sheet of GR record and found that accused Ram Ghimire was arrested on 28/7/2004 and he was produced on the same day before learned JMFC, praying for his remand in judicial custody for 14 days.
You are contradicting it because you are saying that he was not produced on 2, he was produced on 3.
No, Your Lordship. What I'm trying to point out here is that, Your Lordship, on 29/7, again on 29/7, 7 days police remand was given. So my for recording my confessional statement, I was produced before the learned magistrate on 2nd, Your Lordship. And by calculating from 29, my police remand was supposed to end on 4th of August, your lordship. So under such circumstances,
So he is still in police custody.
so he was under such circumstances, I ought to have been ensured by the learned magistrate that I shall not be sent back to the police custody if I refuse to confess my guilt.
Yes.
And secondly, your lordship, the confessional statement at page 32 of paper book, your lordship, I found some strange thing there also, your lordship.
Just a moment.
Yes, your lordship.
Police custody was to end on.
Was to on 29/7 as per para 49, it was on 29/7, 7 days police custody was given. So it was supposed to end on 4 of August 2004. On 2nd, I have been produced. On 3rd, my confessional statement was recorded, but I have not been ensured that I shall not be sent back to the police custody if I refuse to confess my guilt, your lordship.
But you were sent to judicial custody only on 2nd.
On 2nd, I was sent to judicial custody, your
Yes.
lordship. But thereafter, your lordship, if the thing, your lordship, that in that yesterday judgment, that even if I refuse to confess my guilt, I shall not be sent back to police remand, has not been, that assurance has not been given to me by the learned magistrate recording confessional statement, your lordship. And I was under the influence of this police only, your lordship, because at page 32, where the confessional statement is, we can found the confessional statement of Ram Gimire. At the top part, your lordship, I left yesterday today I have seen that.
Where, which part?
Page 32, that is, accused Ram Gimire has appeared. On being asked, the accused states that he wants to make the confessional statement. His handcuffs are removed and all the police officers are asked to leave the courtroom. If I am in judicial custody, why I have not been brought by the jail authority? That means I was being controlled by the police officer on the very day when I was about to make my confessional statement, your lordship.
All right. Yes.
Your lordship, the other submission of learned PP was that learned PP has also relied on last seen theory, your lordship, but none of the PW shows the deceased with the appellant to attract last seen theory, your lordship. Because in the entire deposition of PWs, even the son of the deceased did not state that he saw the accused with the deceased, your lordship, to attract last seen theory. And learned PP relied on the statement of the co-accused Usha Ghimire and Deepa Ghimire, but that was also a retracted statement. That was also retracted during the time of charge and as well as during the time of 313 statement, your lordship.
No last seen theory because he was not seen with accused.
With
She was not seen with accused. She was
yes.
seen with daughter or mother or whoever.
Yes, your lordship. Now,
But their daughter and mother is also other accused.
other co-accused.
Yes.
Now, your lordship, with regard to my submission for non-seizure of weapon and non-examination of the seizure witness, your lordship, because I have been linked, it has been alleged against me that the weapon has been found from my residence, but no seizure witness has been examined in order to prove that seizure, your lordship. To that effect, your lordship, I would like to rely on para 11, your lordship, Para 11 of our Guwahati High Court judgment. Two thousand 14-3 GLR 565. 565. At para 11, your lordship.
Yes.
The prosecution also did not prove the GD entry allegedly made on 14/8/2000 based on the information furnished by Sri Ranjit Boro, who has also not been examined. That apart, the prosecution also did not examine the person who lodged the first information report on 14/8/2000. Though the prosecution has also taken the plea of recovery of weapon of assault as shown by the accused as well as the seizure thereof, the prosecution did not, however, examine any witness to the seizure, though they were 3 in numbers. The investigating officer has also not stated exactly what the accused has said, which lead to the discovery of the weapon of assault as required under Section 27 of the Evidence Act. The prosecution therefore could not prove the recovery of weapon of assault based on the information furnished by the accused leading to this discovery.
Payment judgment leading to discovery.
Yes.
Mhm.
So that is the settled law itself, your lordship.
But this is not a case of leading to discovery.
Your lordship, one part of the judgment, your lordship, I found that this Dow
Leading
was
to discovery.
this Dow recovery of Dow was also relied by the learned trial.
Yes.
Another judgment of the Honorable Guwahati High Court of this Honorable Court with regard to your lordship.
You have any judgment on retracted confessional statement?
Yes, your lordship.
Any judgment on retracted confessional statement?
Yes, your lordship. I have the judgment citation, but I could not due to.
You can give the citation, we'll download the judgment.
Yes, your lordship. Paramananda Pegu versus State of Assam. AIR 2004.
Please write it down. Paramananda Pegu.
Paramananda Pegu versus State of Assam. AIR 2004 SC 4197, your lordship.
This retracted confession.
Yes, your lordship.
AIR.
AIR 2004 SC 4197, your lordship. Here, Lord.
This still holds the field.
Yes, the principle enunciated here is that a retracted confession cannot be acted upon unless corroborated in material particulars, your lordship. Then another judgment, Palanisamy versus State.
Okay, Palaniswamy.
Yes, your lordship.
Please give me the citation.
AIR 1986 SC 593, your lordship. 593.
93.
Yes, your lordship.
Palaniswamy versus.
Palanisamy versus State.
Please write it down and you download these two judgments. Palaniswamy versus State. State of?
It is only State written there, but
Okay.
and
These are all on retracted
on
confessions.
retracted confession. And one more, your lordship, Puran versus State of Punjab.
Not required.
Yes, your lordship.
Two is, I think two judgments will suffice.
Now, your lordship, with regard to this, the accused being in control of police at the time of recording confessional statement, I have one judgment of the
It is
honorable
control
court.
because you are saying that jail authority was not there. The accused was there with the police. His
On the very
instructions
day
to
of
move were not
confessional
the
statement.
police officer were asked to. Okay, a police officer, okay.
So he was not brought by the
Police officer.
judicial authority. In that effect, your lordship,
Yes, yes. Give me
this
the
honorable High Court has recently passed a judgment. Moreover, it appears that even during the period of reflection, Motiram Munda, your lordship.
Motiram
Motiram Munda.
Munda versus State
Motiram
of Assam.
Munda
not
versus
here.
State of Assam.
And what is the citation?
Citation is, your lordship, 2023 5 GLT, page 82. Relevant para is para 42, your lordship.
Para 82,
Para 42, your lordship.
para 42.
Moreover, it appears that even during the period of reflection, the present appellant was kept in charge of a peon and an armed police constable. Hence, as a police personnel was present before the appellant even during the period of reflection, it cannot be said that during that period the appellant was completely out of influence of police. And under such circumstances, his confession may not be regarded as a voluntarily made confession. Hence, for this reason also, Exhibit 3, that is confessional statement of the appellant, becomes tainted and it is not safe to be relied on.
This is only the period of reflection.
Yes, your lordship, my
But this
humble submission is that right from the period from 2 till I did not make the confession before the magistrate, those period are my period of reflection, your lordship.
No, magistrate said it was with the peon only, not with the police personnel.
Pardon, your lordship.
Magistrate
Yes, sir.
said that the accused with for reflection with the
Only
peon.
peon.
Only
Here
peon, not with the police
he
personnel.
he was in with the armed police personnel in this case.
Yes, your lordship.
And this is not relevant.
Yes.
This will not work.
Now, last judgment, your lordship.
So this will not work.
Your lordship.
I'll send it back to you. This won't work.
Your lordship,
What is the point of taking load of judgments which won't help?
Your lordship, in my humble submission, your lordship, the police personnel who itself was investigating the case, if they were there, although they were not in armed.
He has mentioned police officer only, not the police personnel investigating the case.
Yes.
He has mentioned police officer. So the jail authority, they send the accused along with police also.
So
It is not that the accused is brought by the jail authority only. The jail warden, superintendent, etc., etc. They do not bring the accused. The police, they work in tandem. The police and the jail authority, they send the accused in the police van.
yes, I humbly submit respectfully, your lordship.
Yes, yes.
Um,
I'll keep it. I'll refer to it. Maybe
Keep it.
I or you. We will refer to it.
Keep it,
But we'll
keep
keep
it and reject it.
We will keep it.
No, here what the police personnel were also with the peon when it was given, reflection was given,
yes,
reflection time was given.
in my understanding.
So
your
here, in your case, in present case, only peon was there. There's no police personnel.
before recording my confessional statement, I was brought by police personnel, your lordship.
No, police personnel from the authority of the jail, under the authority of the jail. I mean, the personnel
That's
of the
why these
authority.
jail
Obviously, they are
authorities have
police.
not been mentioned. That's why.
Do you say that the jail authority will not deploy the police personnel? Obviously, there will be police personnel from the jail authority, under the jail authority.
So, your lordship, in that respect.
There is a difference.
Yes, your lordship. I do agree, your lordship, but even in that respect, the question whether you have been tortured in the custody ought to have been asked to the accused, your lordship.
That question was not asked.
That question has not been asked in
Okay. I thought I saw that question being asked.
that
Whether
in
you were
page
induced
32
or
itself.
threatened by police to confess? Doesn't that mean it was asked that question?
Yes, your lordship.
Whether, this is the question, whether you are induced or threatened by police to confess, doesn't it imply that he was tortured? Or maybe he was coerced.
Your lordship, but custodial torture is some different thing.
Okay, I'll note it down then.
Where it is? So as,
The judgment yesterday.
not judgment, where it is? You
Uh,
show us, where
it has not been-
indicates
it-
there was a torture.
So that has to be, your lordship, that has to be asked
Inferred.
before recording confessional statement. That is my submission, your lordship. So
No,
that
that's why-
magistrate may be sure that his confession is fair and free from coercion.
That's why this question number 5. Whether you are induced or threatened by the police to confess.
Your lordship, if I may, your lordship, as per my humble submission on behalf of the appellant, the confessional statement, when the magistrate inquires as to the voluntariness of the confessional statement, that has not to be a just mere inquiry. Magistrate should be satisfied that yes, he is confessing free by his own free will, your lordship. That's why in Sivappa judgment, your lordship, in para 6, the Honorable Supreme Court has laid down the guidelines that why he is willing to make the confessional statement which will go against him. This particular question should also be asked. To that extent, the Honorable Supreme Court has laid down the guidelines.
That question was not asked.
That question was not asked.
All right.
That particular judgment I did not submit yesterday. This is relevant.
Only one. Okay. This is relating to confessions.
This is relating to asking
Yes.
why he is
Any judgment
making
relating to retracted confession.
that 3 judgments.
It's okay. These 3 judgments.
Those 3 judgments which have been
Oh, you
recorded.
have,
Yes.
you have just mentioned.
This Pelana
Okay,
Sabi and all.
I'll go through the judgments. I mean, we will go through the judgments.
Yes.
Anything else?
This much.
Concluded.
This much.
Lordship, I'll just point out the 313, Your Lordship, particular questions. If Your Lordship will come to page number 76. The question is at page number 75, Your Lordship. Question number 20,
Page number
75,
313,
313, Your Lordship.
page
75. Question number 20, Your Lordship, the last line.
Yes.
That the PW8 has exhibited the confessional statement of 3 of you and his signature thereon. Their answer, the first answer is of the accused, who says, it is a fact that we have signed many papers, but we do not remember as what was the statement. Now, if I may take Your Lordship to the deposition of the accused, Your Lordship, which is at page number 78.
Hmm.
78, during the cross, Your Lordship will see the last line, which he states that it is a fact that I have given confessional statements as provided under section 164, which is recorded by the magistrate. Now, he does not exactly retract from his confession, Your Lordship.
Retraction of confession.
He has never retracted, Your Lordship. The fact that he admit to the fact that he has given his confessional statement, Your Lordship, and he has not denied the same even in 313, Your Lordship.
Oh, I was under the impression that this was a retracted confession because I didn't go through the 313
Yes.
yesterday.
Even assuming that the statement given under oath is completely different to your lordship, given in the confessional. Your Lordship. Even if we take that is a retracted
Mhm.
confession, your lordship. Even
Okay,
otherwise,
okay.
it has been corroborated.
Or that he has admitted,
Yes.
or there he has retracted.
Yes.
In cross, he has admitted, but there he has retracted
Yes.
in evidence in chief. Okay.
Even under 313, nor in his deposition has he ever mentioned that he was forced or was made any threat was made, your lordship.
Mm.
And lordships has also rightly pointed out that even from a judicial custody, there's a court of police which are being sent guarded with the accused to the court, your lordship. That
In a
is the
police van.
procedure. Yes.
They are always brought in a police van.
And with regard to the examination of the complainant, your lordship, complainant in nowhere is related to the case, your lordship. The complainant's only part was that he has seen the dead body and thereafter he has filed a FIR, your lordship. With regard to the statement of the IO, your lordship, the IO has expired, which is even in the record, your lordship. And therefore his examination was not done and he was, instead of him, the present OC of the police station was examined, your lordship.
Mm.
No question was put up to him, your lordship.
Mm.
With regard to the Caesar witnesses, your lordship will see that though the dao was recovered, your lordship, the dao was already cleaned and therefore even after sending it to the FSL, there was nothing, no examination result as such, your lordship.
That was already washed.
Yes, your lordship. Now, with regard to the questionnaires, your lordship, under 164, your lordship, the Supreme Court does not says, neither the provision provided under 164 says that there has to be certain particular line of questions, your lordship. Only the guideline provided is that this certain type of question has to be asked in order to bring out from the accused that if he was threatened or not, or if has voluntarily come before the magistrate for confession or not, your lordship. If I may take, your lordship, to 164 of the provision, your lordship. Yes, sir.
You read the judgment of this, you saw this judgment instead of that. Sibappa. Do you have that?
Your lordship, paragraph, the plain reading of, it starts from the plain reading of 164, your lordship.
Yes. Yes.
Yes, your lordship.
You downloaded it. Okay. You given what of us? Anything else?
Your lordship,
Lordship,
the
except if I may, your lordship, continue. If I may, as per the
Yes, yes.
question put up, Your Lordship, with regard to Sivappa, Your Lordship.
Yes. Shiva
There is a
Payas?
clear reference to that search inquiry, Your Lordship will say. Inquiry made from the accused as to the custody from which he has been produced and treatment he has been receiving in
Which
such.
paragraph you are going through?
Uh, I have- which paragraph?
Right from 6 to 7.
From 6, Your Lordship.
All right.
06.
Your Lordship, if I may start my submission from before proceeding to record the confessional statement, Your Lordship.
Paragraph 6, yes.
Paragraph 6.
Hmm. Yes.
13th line, Your Lordship. It starts from before
yes,
proceeding.
I
to-
got it.
Yes. Before proceeding to record the confessional statement, a search inquiry must be made from the accused as to the custody from where he was produced and the treatment he had been receiving in such custody in order to ensure that there is no scope for doubt of any sorts of extraneous influence proceeding from the source interested in the prosecution till lurking in the mind of an accused. In case the magistrate discovers on such inquiry that there is ground for such supposition, he should give the accused sufficient time for reflection before he is asked to make his statement and should assure him that during the time of reflection, he is completely out of police influence. An accused should particularly be asked the reason why he wants to make a statement which would surely go against his self-interest in course of the trial, even if he contributes subsequently to retract the confession. Beside administrating the caution, Your Lordship will see that's a caution. Warning specifically provided for the for in the first part of subsection 2 of sections 164, namely that the accused is not bound to make a statement and that if he makes one, it may be used against him as the evidence in relation to his compliance in the offense at the trial that is to be followed. He should also, in plain language, be assured of protection from any source of apprehension. Your Lordship will see there has to be an inquiry. Subsequently, certain questions, Your Lordship will also see that reason for him to make a statement and that he should, in a plain language, he should be assured that he is protected, Your Lordship. Now, in the confessional statement, if I may read,
Before that you read, an accused should particularly be asked the reason why he wants to make a statement.
which,
Particular reason,
yes, Your
just
Lordship.
above that. Besides, an accused should be particularly.
Yes, Your Lordship, if I may now read the confessional statement in full, Your Lordship. Accused Ram Gimire has appeared. On being asked, the accused says that he wants to make the confessional statement. He has been asked, Your Lordship.
No, you should be asked particular reason
Yes,
why he wants to make confession. As per the judgment.
yes, Your Lord.
So this was recorded by an executive magistrate. Do they have that format? They do not have. And they never used to have in those days.
2004, Your Lordship.
Obvious.
Now we have the format, complete format. Anything else?
No, Your Lordship.
Okay then. Concluded.
In conclusion, Your Lordship,
Hmm?
while concluding, Your Lordship, I just learned PP has just made a submission to
You cannot allow it to go on like this.
Yes, yes. I think it's
Otherwise,
enough.
it will take months, years together if you allow such type of argument.
Yeah, I think it's concluded.
Yes. But just single
Yes,
line,
yes,
yes, Your Lordship.
Again, she would like to reply again. Again, you will reply.
Only on law points.
Yes.
Only on law points.
Nowhere in 313 or in any deposition, it has been confirmed that the confessional statement was made voluntarily. That much only I had to submit here. That yes, it has been written there that I have signed many papers in 313. And in this cross of Ram Gimire, he stated that I have signed confessional statement, but he did not state that I have signed it willingly. Your Lordship.
But you didn't say that you didn't, you are forced to give the confessional statement or influenced. You have just said, I've said maybe many papers, I don't remember what statement was there.
Yes.
You didn't say anything more than that. You say, you never said that it was under the influence or you have been forced to make a confessional statement. Nothing is there. 313.
It's Raju Kumar Deka is by APP.
Yes.
No, you have submitted this
Yes.
appellant. Permanent Pegu also appellant.
Appellant.
Palana Swami appellant,
Appellant.
obviously. Shivappa appellant.
Appellant.
This I will not refer to. Konak Boro appellant.
Appellant. Answer, my lord. Deeply obsessed.
Madam, in this matter, I am yet to file affidavit.
Hmm?
I am yet to file affidavit.
You want to file affidavit?
Yes, madam.
Yes.
Matter will be listed after 3 weeks.
Have you taken consent from the other?
Yes, I am
side?
taking consent.
Learned counsel Mr. C Modi with the consent of the
Om
other
Modi.
side. Huh?
Om Modi.
Oh Modi, okay. Has prayed for time to file affidavit. List the matter after 3 weeks.
Yes. Okay.
May I, your lordship?
24, no?
24.
24.
May I?
You are on the other side.
Yes, your lordship.
For 24.
And so I'm for, this one, I'm adjourning item number 26, your lordship.
Hmm.
This matter may be listed after 2 weeks, your lordship.
We have not received the instruction for filing counter affidavit
Ah,
in item number 26, Your Lordship.
item number 26, learned government advocate Miss
P. Pangu, Your Lordship.
P. Pang
Pangu, Your Lordship.
Pangwe, P. Pangwe, learned government advocate AP, Arunachal Pradesh. Miss P. Pangwe has prayed for time to obtain instructions.
Yes.
Liz, full stop. You have taken the consent of the other side.
Yes, Your Lordship.
List the matter after
2 weeks, Your
2
Lordship.
weeks.
Oblige, Your Lordship.
My lordship,
Mm.
I beg to mention item number 31.
13,
31.
31.
My senior
Yes.
counsel is out of station.
Learned counsel, Mr.
C. Modi.
C. Modi, on behalf of learned counsel, Mr. Udeka.
No, my lord, my name is M. Lego. Sorry. I on
Okay.
behalf of C. Modi.
Learned counsel, Mr. M.
M. Lego.
Your name is not in the cause list.
Yes, my lord.
Not in the
Not,
cause list. On behalf of Mr. C. Modi, with the consent of the other side has prayed for adjournment. This is the matter on
after 3 weeks
3 weeks, after 3 weeks.
of last month.
May I, Lordship, Lordship, I
Yes.
beg to mention item number 29.
29.
Yes,
Yes.
as the leading counsel, due to some personal difficulties, could not come today, Lordship. The matter may be listed up to 3 weeks.
Learned counsel, Mr. So on behalf of learned counsel, Mr. R. Soikia
Yes, Lordship.
has come up with the consent of the others.
My name is there, Lordship. B type
Eh, oh, your name is there and it was required there. Learned counsel, Mr. B. Typodia, with the consent of the other side,
Yes.
has prayed for adjournment. List the matter after 3 weeks.
3 weeks, Lordship. Obliged, Lordship.
Your Lordship, I beg to mention item number 2, 3, 4, 5, and 6.
2, 3, 4,
4,
5,
5.
and 6.
For the respondent number 4,
Respondent
appearing
number
on behalf of learned senior counsel Takam Sunil.
Takam
Sunil, yes.
Uh,
Your Lordship, we are going to file additional affidavit. So this matter may be listed after 2 weeks. I have obtained consent from the opposite party.
Yes,
Yes, Lordship, interim is that it may be continued.
okay. Learned counsel, Miss N. Duggan
Yes.
is present on behalf of the petitioners. 2, 3, 4, 5, and 6, full stop. Learned counsel, Miss
M. Yaram,
Yagam on behalf of learned counsel.
Takam Sunil.
Is for standing counsel or anything?
Standing counsel, yes.
Standing
No,
counsel?
Lordship, not standing counsel.
Not standing.
Council, only council.
Counsel, okay.
Also for the deputy.
On behalf of,
Council for the deputy commissioner.
okay, learned counsel for the deputy commissioner, Mr. T. Sunil has prayed for adjournment, has prayed for time to file
Affidavit, additional affidavit.
additional affidavit.
Yes.
List them at,
I'm for the union opinion.
oh, okay. Before this, before the last line, learned counsel, Mr. M. Kato is, learned DSGI
My lord.
is present. Then you write this other sentence.
Fine.
List the matter after 3 weeks.
2 weeks.
2 weeks.
DP of life.
May I, Lordship?
Yes, yes.
I beg to mention item number 28,
70,
28,
28.
28. I'm on behalf of leading counsel, Mr. N. Pada. And we need more time to file counter affidavit. So kindly this matter may be listed after 3 weeks.
Lordship, item number 20.
27 and 28, I have 27. Petition order.
Analogous. 27 with
Not
20.
exactly
Exactly,
analogous.
no, this is
Then,
separate issues there.
Okay, turn by turn, I'll pass the order. 28, who is for 28?
I'm 28. With regard to 28,
28,
there is the
yes.
interim order that may be continued.
Oh, last order also.
Yes,
Interim order shall remain in force. Till then,
Interim order may be continued.
28 learned counsel, Mr.
J. Apum.
For the
Ji-
petitioner.
For the petition, this, for the petition.
For the respondent number 3.
And
Okay,
the
okay. You're for the petitioner.
yes.
Learned counsel, Mr. T. Tapar,
Take up.
is present on behalf of the petitioner. Learned counsel, Mr. So-and-so, on behalf of learned counsel for the respondent, Mr. N. Pada, has prayed for 2 weeks' time,
3 weeks.
3 weeks' time to file affidavit.
And affidavit.
My matter will be released. Separately.
27.
Yes, Lordship.
Interim order shall remain in force till then. 27, you are present here.
No, I'm only representing 27. I have no interim, Lordship.
Okay.
That's why I'm trying to get.
27, you are the petitioner in
Yes,
27.
Lordship.
Learned Counsel Mr.
Chief Procon.
G. Pukon is present on 27 on behalf of the petitioner. Who is prayed for adjournment?
No,
The
Lordship.
other side.
I am not, Lordship.
Nobody is
But-
present.
Yes,
Government advocate. No. You are for the petitioner?
I am for petitioner. Item number 27.
So nobody is present for the government.
No, Lordship.
This is at the stage of admission. Orders. This is at the stage of orders.
28.
No, this is 27.
27.
Notices of this will be issued. They are here to give us extra copies.
Already I have served, Lordship, to the insurance company also.
No, extra copy.
Actually, I have already
You
served.
made a
Yes. My prayer is for interim, Lordship. As because there have no.
Today?
Yes, Lordship. As
No,
there,
no,
as there is no
you
state
Serve
consumer
the
here.
notice first, you serve the notice first.
Yes. Some copy to us. Where? Extra copy. When? Only one you have given, extra copy you have to serve.
You have received a notice or you have not received?
No, notice, Lordship.
Ah.
It was moved on 18/3/24, Lordship, of course, and notice was issued. They were supposed to give us extra copy, but then
You have not given.
they
extra
haven't
copies.
furnished us
I
extra,
have served,
not
but
even.
for my client, Lordship.
Learned counsel for the petitioner, Mr. G. Pukon is present. Learned government advocate, senior government advocate.
Additional senior government.
Learned AAG, Miss G. Ete, has submitted that extra copies has not been furnished to the respondents. The petitioner to furnish sufficient copies of the petition along with the documents annexed thereto to the respondents during the course of the day
Yes.
or within 2 days.
Today, Lordship.
Today, during the course of the day, list the matter on
16th. 16th of May.
Yes. You have the timetable with you. Can be listed on 16th.
Bless.
This matter may be tagged with this same matter, Lordship, 326. Because we have filed our affidavit in this
Which
matter,
one?
similar matter, 326,
Along,
Lordship,
list the matter along with WPC number 326
of 2023,
of 20.
23.
Bless.
Lordship, I pray for a listing of WPC 17 of 2024 for withdrawal.
For
withdrawal.
withdrawal
Yes.
tomorrow, Monday,
For Lordship tomorrow.
for tomorrow.
Yes.
Ma'am, my lordship, I beg to mention item number 7, my lordship.
Mm.
We have received the instructions, my lordship. We need some more time to file affidavit.
You haven't received instructions?
We have received.
You have received, okay. So you'll be filing your, you are for the government?
Yes, my lordship.
You'll be filing your affidavit. Learned counsel, Miss G, Miss K. Wangmo, no?
Yes, ma'am.
Learned government advocate, huh? Learned government advocate, Arunachal Pradesh, Miss K. Wangmo has submitted that they have received, as they have received instructions, they'll be filing their affidavit in opposition. List the matter after 3 weeks.
Yes. And one more, my lordship. Item number 8 to 19, my lordship.
8 to 19.
Even in this, we have received instructions, my lordship.
8 to 19.
Yes, ma'am.
Same order.
Here, Your Honor, interim is there. Let it be continued.
Which one?
8 to 19.
Oh, interim order shall, Mr. Learned Counsel, first you write, Learned Counsel, Mr. D.K. Devi is present on behalf of the petitioner, 8 to 19, huh? Then you write the other part. Then last part you write, interim order shall remain in force till then. Yes.
Right.
My lord,
Mm.
here, respondent number 3 and 4 supposed to file counter affidavit here.
They have not filed.
Yes,
Respondent number, who is for respondent number 3 and 4?
3 and 4.
Lordship, because of some lack of documents, our affidavit is not ready yet. Kindly give us last opportunity to file affidavit.
Your Lordship, I have an objection here. Since last 4 occasions, they have taken time to file by submitting that affidavit opposition has been ready, but within a period of such and such, they're going to file. But till that, since 4 occasions, they have short time. But till that, yeah, submitting same. First, they have short time on 5th September 2023. The second short 14th March 2024. And third 26 March 2024. And fourth 4th April 2024. They have submitting same statement by saying that their affidavit is ready. Even one occasion on 14th March 2024, this Honorable Court had especially directed to file affidavit in opposition on 19/03/2024, but they yet not filed till that. The respondent number 2 has already filed counter affidavit, and accordingly, I have filed affidavit in reply on 26th March 2024.
They have been newly engaged.
Your Worship?
They have been newly engaged.
Yes, they have been.
This case is old, no doubt about it. This case is old, but they 3 and 4.
He has been engaged on 5th September 2023 by the service has been complete on 14th June 2023. My Lordship.
I think he's speaking for his senior. You're speaking for your senior,
Yes,
submitting
Lordship.
for your senior.
Yes, Lordship.
Same submission has been made last for
By him. Always by him.
No. Yes, junior has been engaged by senior. On behalf of Nalopada sir, the junior has
On
been
behalf of?
Nalopada in father. Twenty-six. 26 March 2024.
For the DC, you are appearing for the
Yes,
DC.
yes, we have filed.
And 3 and 4 are private respondents.
Yes, private.
Why you have any arrayed private respondents? This is land acquisition case.
So my Lordship, herein the fact is that the Deputy Commissioner called back his own order after lapse of 5 months, whereby the respondent 4 submitted some representation before the Deputy Commissioner. Basing on that, the Deputy Commissioner has acted without authority of law and called back his own judgment and order after lapse of 5 months. That's the main issue. Whether here issue is single, issue is only one, whether the Deputy Commissioner has authority to call back his own order after lapse of 5 months. under the provision of Arunachal Pradesh Land Settlement Records Act 2000. That is the only issue, my lord.
Let us give you one last chance. Then next day we will proceed for admission.
Because LPC is issued in the name of the petitioner, your lordship. LPC.
Oh,
Land
So
allotment.
land allotment, your lordship. He's challenging the land allotment of the private respondent number 3.
so what to do? We'll give him one last chance. One last chance.
Okay.
He's in interim,
Yes, I will do.
so that has been stayed, so he is also suffering. The order has been stayed, so he is also suffering. I do not know why they are not submitting. One last chance.
One last chance. Failing which, on basing on report, matter may be proceed further. In case if the respondent number 3 and 4
I
fail.
pass an order, yes.
Okay.
On merits, yes. Heard, Mr.
Your lordship, Tabat Tokur.
T. Tar.
Tokur, Tokur.
No, you are not.
Tabat Tokur.
T. Tokur, learned counsel for the petitioner, comma, Miss R. Basar, lordship, comma, learned government advocate, yes, lordship, for the respondent number 1 and 2, yes, and Mr.
J. Apum.
J.
Apum.
You are on Mr. J. Apung on behalf of learned counsel, Mr.
N. Pada.
And learned counsel, Mr. J. Apung on behalf of learned counsel, Mr. N. Pada. Who stopped the
Lordship, I'm for 2 only, not 1.
1, respondent number 1.
For 2.
For respondent number 2. For respondent number 3 and 4. Who is for 1?
1 is for land management, your lordship, standing counsel.
He is just performer respondent.
The learned counsel, Mr. The learned counsel for the respondents number 3 and 4 has prayed for time to submit their written objection, to submit their affidavit in opposition. Affidavit in reply.
Position.
I'll just mention affidavit. You have earlier filed or affidavit? No. So affidavit. Prayed for time to submit the affidavit. The learned counsel, full stop, the learned counsel for the petitioner has raised objections stating that the matter is pending since 7/9/2022, and on several pretexts, the respondents have been taking adjournments, full stop, for the interest of justice. Last opportunity is accorded. The respondents number 3 and 4 out of 5 their affidavit positively, failing which this case will proceed and order will be passed on merits. All right. And necessary order will be passed on merits of the case.
Your lordship, I have this
This the matter after 3 weeks.
No, respondent number 2 has filed counter affidavit, and in person to that, I filed affidavit in reply.
It is also submitted by the learned counsel for the petitioner that he will file affidavit in reply.
I already filed.
Huh?
Already
You have
filed.
already filed.
Yes.
I think it's mentioned here.
Okay.
This in last sentence, you just check it out. It will be mentioned here.
After lordship.
3 weeks.
Much over. Continue, my lordship, that interim may be continued.
Okay. Interim order shall remain in force till then.
Much over.
Item number 20 to 23.
May I please?
Yes.
Lordship, here respondent number 2 and 3 are yet to file affidavit in opposition.
I'm for respondent number 6, lordship. We have already filed.
Respondent number 2 and 3 is
2 and 3.
not represented today. They are not present today. He is for respondent number
I'm for respondent number 6, lord.
6. He is for respondent number 6. But they have not filed affidavit.
They have not filed.
2 and 3 have not filed. Learned counsel, Mr.
M. Khambo.
M. Khambo is present on behalf of the petitioner. Learned counsel, Mr.
K lawyer.
And learned counsel,
K
Mr. K. Loya is present on behalf of the respondent number 6, full stop. The respondent number 2 and 3 is not represented today, nor any affidavit is filed. The office note dated 8/5/2024 indicates that no affidavit has been filed on behalf of respondent number 2 and 3. Full stop. 2 weeks time is accorded to the respondents to file affidavit in opposition positively. You are for 2 and 3?
No.
No, Your Lordship, I am for 1, 4 and 5.
1, 4 and 5. 2 weeks time is accorded to the respondent number 2 and 3 to file affidavit in opposition positively, failing which this case will proceed. This case will be disposed of, this case will be decided on merits, disposed of now, decided on merits. Learned counsel, Miss P. Sangeeta.
Yes, Your Lordship.
Is present on behalf of.
May I, Your
Eto
Lordship?
agon likhi diba. Yes, yes, yes. Yes, you may.
Private.
Your Lordship, P. Sangeeta, Your Lordship, but here, Your Lordship, Land Management Department, they have their standing counsel, Mr. Lee Kamduk. He was supposed to file counter affidavit. And he had some difficulty in appearing this case.
Oh, okay.
So he has instructed us to appear on for the department.
For 2 and 3. Learned counsel for 2 and 3.
Yes, 2 and 3, yes.
Okay, to
We'll be filing counter affidavit for 2 and 3 also.
For
land
last sentence to Kati. Learned the government advocate, Miss P.
Yes.
Sangeeta has submitted that 2 and 3 is not represented to Katidia. Has submitted that has submitted on behalf of learned counsel for a respondent number 2 and 3 that that affidavit will be filed. Huh?
Filed, yes, Your Lordship.
That affidavit will be filed after.
Well, you will need some time, Your Lordship, because
that
we have
2
to.
weeks, that some time may be allowed to file affidavit. All right. Then list the matter after.
3 weeks, Your Lordship.
And you are also present on behalf of?
I'm present on behalf of 1, 4 and 5. That is
Edu eta likhi diba. Mazot
DC,
mazot
Lord,
khai diba.
yes.
A last sentence of mazot.
and I'll also be presenting representing Land Management Department. That is 2 and 3.
2 and 3.
Yes. In this case only.
In this case. It is further submitted last of Bridiba that learned counsel learned government advocate Miss P. Sangeeta will be representing the respondents number 2 and 3.
Yes, sir.
Also. Oh no, also I say. 3 weeks call me.
Highly obliged.
3 weeks.
Yes, yes.
I pray Lordship give me some more time to fight fresh steps to respondent number 1 and 3 through the registered.
I'm appearing for respondent number 3 on behalf of G. Kato, Your Lordship.
Hmm?
I'm appearing for respondent number 3 on
Respondent
behalf
number
of
3.
G. Kato.
Learned counsel Miss
K. Nada.
K.
Nada.
Item number 25.
It's written as K. N. Maling, you say. K. N. Maling. 25.
K.
Yeah, K. Nada, Your Lordship.
Your name is not in the cause
Collect
list.
number में दिया हमें यहाँ में reflect नहीं content में पता नहीं ना
Not in the cause list. Learned counsel Miss K.
Nada.
Nana.
Yeah. NADA.
Is present on behalf of the petitioners. The learned counsel has prayed for some time to issue notice to respondent number
1 and 2.
1 and 2.
Through the by registered press step. Press step, Your Lordship.
The post of the learned counsel for the petitioner may take fresh steps to issue notice to respondent number 1 and 2 returnable within 2 weeks. Learned counsel Mr.
M. Tangzang.
M. Tanja
Yes, Your Honor.
on behalf of
Respondent number 3 On behalf of G. Kato.
On behalf of learned counsel, Mr. G. Kato is present for respondent number 3. List the matter after, you said 3 weeks, no?
Yes.
List the matter after 3 weeks.
Much obliged, Your Honor.
Obliged, Your Lordship.
Lordship, this is
That day before yesterday, no?
regarding appointment.
Do you have the
This
documents?
is hearing, matter is on hearing,
I heard the matter, no?
not part heard. This is not part heard.
Okay.
Yes. I'm submitting.
I yesterday, day before yesterday, I think I have heard a matter.
It was another thing.
Okay.
That was a land matter.
Okay.
Now this is a service matter.
Service matter. Okay.
Yes.
So this is hearing?
Yes.
Okay.
First of all, Lordship, I am for appointment to the post of MTS, multitasking staff. My right to appointment starts from Lordship, page number 15, annexure 1. This is the appointment order. Yes, I'll read it.
Page number 15?
My WP, page number 15, annexure 1. What it is written here. Application in prescribed form are invited from the eligible candidate for filling up of posts of following Group C, MPW, and MTS categories of posts under the establishment of District Medical Officer, Upper Siang District, Yingkiong. There were this MPWs, there is a 4 number of posts was vacant. For that, the director concerned has directed the district medical officer to go for recruitment. And other than that, in addition to that, MTS, various MTS, inclusive of all, there was a 34 posts, vacant posts, clear vacant posts. For
What
which,
is the full form? Medical MPW
MTS. MTS. Multitasking, sir.
and MPW?
MPW is, that is also Group C post.
Multitasking staff and
Malaria prevention worker.
malaria prevention worker.
Prevention worker.
I should know, but I do not know. My husband is
No,
doctor.
whatever it may be, it is for Group C post, all are Group C post. Kindly see in the scale pay is prescribed, S is prescribed, minimum educational qualification is prescribed, and method of recruitment rule is also prescribed in the column 4. And post allocation as per merit list and roster. Accordingly, on the basis of this advertisement, the petitioners have applied for appointment in the post. So accordingly, and on the basis of call letter, they sit in the examination and they have been selected in the waiting list. Waiting list. Kindly see in the waiting list. What is here? Waiting list. Proper. Waiting list is I'm on the waiting list in my name is page number 28, annexure 11. Page number 28 of WP, annexure 11.
They have been selected, but their name is
No,
in the
no.
waiting list.
I was on the waiting list. What is here? At the time of filing this WP, all the requisite documents were not furnished despite of my asking for furnishing of all those documents. So I have only enclosed the waiting list here. In the waiting list, there is a list of waiting list candidate in which my name is this petitioner's name is reflected in.
Is he on? Is he on? On थोड़ा कम कर थोड़ा
बंद कर दो.
नहीं AC चाहिए थोड़ा कितना में है 20 21. 17.
My name is, the petitioner's name is reflected in the serial number 2 and 3 in the waiting list candidate.
Okay, serial number 2 and 3.
3 in the page number annexure 11, page number 20 of the WP. My name. Then,
Say 11.
then as per the result notification, in the result notification, Lordship, what had happened? Although advertisement was for our basic grievances in this case is advertised post was for 34 posts, clear vacant posts. But in the result notification, what had happened? Result only 27 candidate has been selected on merit. Only 27. In the affidavit in reply by way of on the basis of this RTA information feeding from RTA.
But only how many? 27 candidates were selected.
27 candidates were selected on merit under reserve quota. That is reserve quota. In the result,
Yes.
result notification is in the result notification. And one more, this list is there. That is a unreserved quota, which means general quota. In the general quota, 4 number of candidate has been filled. And
General quota for
4 number of candidate. And one more candidate, disability, person with disability quota. This one person was appointed.
Yes.
And one more candidate was appointed. That was on the basis of compassionate appointment. This means total appointed candidate is Lordship.
27 plus 6.
Yes, total appointed candidate is
33.
yes, 33. 27 plus 4 plus 1 plus 1.
33.
33 candidate. Whereas Lordship, in this case, what had happened, as for this advertisement was for 34 candidate, but there is a mess up. There is a serious defect in the recruitment process because there cannot be, as per the recruitment rule, there cannot be examination for reserved quota, unreserved quota. Unreserved quota, over the unreserved quota, there is a, in Arunachal Pradesh, state of Arunachal Pradesh, in as per the service rule, there is a reserved quota. Reserved quota is for scheduled tribe candidate. And unreserved quota, over the unreserved quota, any person, a citizen of India can participate in that unreserved quota. But in that result notification, what had happened? Reserved quota has for unreserved quota, there is a reservation. 4 number of person has been given on reserved quota, unreserved quota. General category candidate has been reserved for general category candidate. Whereas over the general category candidate also, there should be competitive examination. Over the unreserved quota also, the ST candidate, scheduled tribe candidate can also participate. The selection should be on the basis of merit. Over the unreserved quota also, the ST candidate can also compete over that quota. Whereas in this case, what had happened? Over the reserved quota, unreserved quota, the ST candidate cannot participate in the process. That is why Lordship, in the result notification.
No, just now you said ST candidate can participate in the unreserved.
Unreserved post.
Now again you're saying cannot participate in the.
I'm
unreserved quota.
I'm saying.
Beyond the pleadings, my lord.
I'm. Whatever.
And then you cannot go beyond the pleadings.
Full length, I may be giving full length submission.
Yes, yes.
Then. I am to say this result notification is defective. Because first, what is the first defect is out of 34 candidates, only 33 candidates has been appointed. That is the one of the defect. And number two defect is as per the result notification, only 27 candidates have been appointed. Whereas advertisement is for 34 posts, 27 candidates. Why, Lordship? Because over the compassionate appointment, when the post is for compassionate appointment, over the compassionate appointment post, there cannot be any competitive examination. First of all, that is the rule, service law. Because one of the posts is for compassionate appointment. When compassionate appointment comes, there cannot be any competitive examination.
Mention anything in your pleadings.
Lordship, but law is law. Lordship, I am pleading over the law. That is the law. Law is even beyond pleading. Law is always law. Lordship, and physically this in this notification, this advertisement, there is nothing in no category has been prescribed. Neither for general category candidate, nor for reserve candidate, nor for physically person with disability. But in the result notification, compassionate appointment, the candidate who has been given a compassionate appointment is on the list within the 33 appointed candidate. And person with disability is also on list. And whereas, if that is the projected case of the government, then only on merit, they have only 27 candidates has been appointed. So, we can't, instead of publishing our name in the merit list for appointment, we have been placed on waiting list. Whereas, when there is 27 and our serial number should be 28 and 29. In that case, we are coming under the zone of consideration for appointment on the basis of that recruitment process. That is our claim.
First of all, you tell me that these two, your petitioners,
Yes.
they belong to which category?
We are scheduled tribe category, Arunachal Pradesh scheduled tribe category. And now I am submitting on this private respondent, over the private respondent issue, that why we have implemented that private respondent as a party in the case. Because kindly see, Lordship, and page number 36, my WP, annexure 14. After the result notification, we have observed that the person who have not sit in the examination also been appointed. Whereas, as per the result notification, there is a clear cut advertised post is 33, out of which.
So these respondents, they did not sit in the examination, but they were
Yeah,
appointed.
they did not sit in the examination. So we filed a complaint before the deputy commissioner, who was the chairman of the recruitment process, Ying Kyung, deputy commissioner. So what they have before the competent authority, before the Ying Kyung, district medical officer Ying Kyung. So district medical officer Ying Kyung has written a reply to the deputy commissioner concerned, who was the chairman of the recruitment process. In the page number 12, on 12th of February 2018, what they have replied, public complaint, subject is public complaint, regarding public complaint, your letter number. This letter has been given to the district medical officer. Kindly see what was his clarification. Clarification says, it is to inform you that by this office order number such and such, the advertisement recruitment for the following posts were carried out, in which MPW number 4, what I have stated earlier, that is not to be reiterated. And total number is 34 posts. Total post is 34, what I have stated. And based on the written examination dated 21 August 2016 and Viva was test dated 4 November 2016. The final result declared on 5th November 2016 and appointment has been done accordingly to select all candidates. Also, list of 10 candidates have been kept in waiting list for 34 posts. So that if any candidate selected fails to join or resign within 6 months from the date of declaration of result, the waiting list candidate as per merit will automatically take its place. That means waiting lists are valid for 6 months and for above 34 posts only. 34 posts only. On the other hand, that is the clarification with regard to the private respondent. On the other hand, 2 posts on which Miss Gagul Lego nursing assistant and Srimati Kasemang Jijong sanitary assistant were regularized from senior most contingency on DPC recommendation dated such and such Director Health Services such and such under promotional quota and not included in the 34 posts. They have clarified that this private respondent appointment of private respondent is does not come under the 34 advertised post, but existing vacant post. From the existing vacant post,
because they have this
because they were the serving contingency staff.
departmental
Yes,
professional
as per the
committee.
recruitment existing standing recruitment rule of
There
the
is
serving.
always
They have-
certain criteria
that is
in
why-
every office
Yes,
to
that is
give
why.
permission from the contingencies.
Yes, that is why in my pleading, Lordship, kindly see, in the page number 5, paragraph 3, I have.
So
clearly
this,
stated.
that is why they did not sit for examinations. The
Yes,
respondent.
yes, private respondent, with regard to, I do not have any grievances with the private respondent.
Why not we read para 10 also?
Kindly see,
Explain.
kindly see.
Para 10 of what?
Para 10
I'm-
explain.
I will miss my point, Lordship.
You'll forget.
Full length submission.
You'll miss, you'll forget. You'll go for a toss.
Lordship, paragraph 3 of my WP, I have clearly stated that the private respondent number 4 and 5 are the persons who may be affected by outcome of this writ petition. And therefore, they have been added as private respondent, although they have not participated in the competitive exam in terms of the advertisement. That is why we thought that although they have, because only on the basis of competitive examination, 27 posts were appointed. 27% were posts in the advertised posts. Although the private respondent were not sit in the examination, they have been given appointed, but the district medical officer concerned has clarified that although they have not sit in the examination, they have been appointed because they were the senior most contingency staff. As per the recruitment rule, they have been appointed. That was the stand of the district medical officer. So I do not have any grievances against both the private respondents. And apart from that, Lordship, because they may be, I have just said they may be affected, Lordship. In this case, Lordship,
You file reason.
no, yes, regional. In the given situation, Lordship, in the given situation,
Yes, yes.
if the government one more one more thing is there,
Hmm.
very important thing. In my rejoinder application, I have made, in my rejoinder application, I have replied, Lordship. Yes, rejoinder. Kindly see, Lordship.
Rejoinder name. From where you are reading?
We have not.
This. Kindly see this. What is that? This official communication page, rejoinder application, page number 20 and annexure 5. My reply to government affidavit.
We have not received.
Let him read. No problem.
That is not a very big issue, even then I can clarify this.
But we should know what we have.
Oh, okay.
This is affidavit in opposition.
Yes, affidavit in reply against the government affidavit.
Rejoinder, we have not
Rejo-
received.
Rejoinder.
When did you submit?
Rejoinder.
Affidavit in opposition. This is affidavit in opposition.
Office note, my lord.
Respondent number 4. I'll just check
One
the office note
copy
there.
is the copy is I am serving the copy. Yeah.
Okay.
Yes. That will do. That will suffice. Suffice the situation. One rejoinder application in the page.
8/5/2004, 24. Affidavit in reply not yet submitted. We have not received. No.
No, you cannot rely.
I have-
No,
I have-
you cannot.
I have filed.
Is.
Then, Lordship, if it is not submitted,
Not submitted.
I have to verify the record.
Hmm.
Next day. Lordship.
I cannot find it.
No, no.
That's why he suggested that I should go to the
Yes.
office note and office note.
Uh,
Yesterday's office note.
I will clarify the matter. Matter may posted on next week.
No, full length argument as well at once. Please.
Full length argument next week.
Next week.
Let him serve the copy today. Yeah.
I will clarify this, check the record, whether I have filed this copy or not, because of this miscommunication here.
There's no in this, even in the order also.
I have already.
I'll pass an order. This is item number 25.
Yes.
Learned Counsel Mr. S. Mao.
30, item number 30.
30.
30.
Learned Counsel Mr. T. Taki.
But now the
within-
simple
within
thing
the-
is, my brother has gone on a full length argument. Sufficient time was given. Now,
Now he has
Yeah.
rejoined.
no, because once the hearing has started, he cannot recourse for rejoinder application. You cannot. Because, no, because he has not filed.
Not filed.
He has not filed. So therefore, the
But he is
contents,
proposed to file.
no, but then he ought to have come with a clean hand.
No.
So,
He was not aware, you see.
no. Well, there's just one question if I raise this.
See,
court.
there's an order also. There's an order also.
My lord will only point out one thing. I'll point out one thing in this case without turning the pages, my lord. My lord will kindly note, this was filed on
2018, 16.
29/5/2018. Way, for the interest of justice, my brother Tapa always comes out with one.
Next date for
I
disposal.
think in the year
In the meantime.
2022, one order has been passed to file affidavit in reply, I believe.
Anyway.
There may be mistake, Lordship. I have engage my junior to
Because
file
here-
whether they are mistaken that is a mistake from my junior. I am told that everything is all right, already filed. On my record, I have the copy.
Now, my lord, again, the difficulty is he has not filed rejoinder against my affidavit. That means he has admitted my contention. So without controverting it, so what is the point of advancing any argument?
31/8/2022 list this case on 12/9/22 before that the affidavit, the reply affidavit may be filed. So you were given the last chance also,
Yes.
long time back, but still then you didn't file the affidavit.
Yes.
Hmm.
Let dismiss it, my lord, for this.
Actually, I have given to my filing section that.
No, no.
I do not
It's
know
my-
what will
there-
be
there
the
may be
outcome of this examination.
Every copy.
It's a port category case, no?
Port, C
Port
category.
grade
Yeah, port grade.
post. Okay. And they were in the waiting list and they were waiting
Yes.
already. Had
Titapak.
Mr. T. Tapak, learned counsel for the petitioner, comma, Mr. T. Tara, learned counsel for the respondent, which
Five and six.
respondent number 5 and 6, Miss R, government advocate,
And
Miss
for
R.
four.
Basar,
And for 4.
for respondent number 4 and Mr.
For the standing council.
Learned standing on,
Also for the health.
and learned counsel, Mr. 9.
Nine.
T. Tagum on
Fix
behalf
it
of
on.
the standing council, Mr.
Standing council is Peter.
On behalf of
Oh.
Mr. T. Tagum, standing counsel. Health
And
Department.
what is your name? Elika. On behalf of Mr. T. Tagum, learned standing counsel for the learned standing counsel for respondent number so and so. The learned counsel for the petitioner has submitted that he is yet to file affidavit in reply. Full stop. Last opportunity is accorded to file affidavit in reply. List the matter on
21.
20,
21. 1 week.
21,
1 week time is the
21 for affidavit in reply. So please file the affidavit in
Yeah,
reply since 2022.
Yes.
My lord, some cost should be imposed because my brother has attained the court and asked